returned against the defendant. The first charged him with the crime of grand larceny in the second degree. He was charged with the crime of grand larceny. It was alleged that on the 10th day of September of this year, or about that day, he stole 52 pairs of shoes of the value of $55 a pair from a corporation called the Brown Express Company. There is another count charging him with criminally receiving stolen property after it had been stolen. The district attorney has elected to abandon the first count, and the question before you at this time is to decide whether he is apparently guilty of the crime charged in the second count, namely that with guilty knowledge and intent he received from someone else stolen property. That is a very simple crime. First, there must be stolen property. It is conceded here that the shoes were stolen. A quantity of shoes that were shipped in 5 paper cartons to a store in New York County. 3 of those cartons were delivered and 2 were stolen from the express company on the way. Some of the shoes so stolen were found in the possession of the defendant. The claim of the people is that he had those stolen shoes in his possession with apparent guilty knowledge and intent. Under our law, if he had the shoes in his possession after they were stolen, no matter by whom they were stolen, with guilty knowledge that he had stolen property in his possession and with guilty intent, then he is guilty of the crime known as criminally receiving stolen property. The law is that notwithstanding the finding of an indictment, he is presumed to be innocent. The indictment is only a charge. It is the means adopted by society to bring the man charged with crime before the proper tribunal to have that question decided. You have heard me say every day when these cases were called for trial that I am simply here waiting for the district attorney to bring in some business. And when he puts an indictment on the calendar, it is a demand upon me to try it, and I get busy and try it. That does not mean that the defendant is guilty, but that he must come in to answer that charge, and that at the time he is presumed to be innocent. That is, the burden is on the people of proving him guilty beyond a reasonable doubt, otherwise he must go free. What does a reasonable doubt mean? It means a doubt based on reason. It does not mean a doubt based on sympathy for a man on account of his age or condition or race or creed. It is not any possible doubt that someone may conjure up to avoid doing his duty if it is disagreeable, but it is the state of mind that an honest juror finds himself in when, after listening carefully to all the evidence, he is unable to say that he is firmly convinced to a moral certainty that the defendant is guilty. The evidence must produce in your minds a strong conviction he is apparently guilty. What is the evidence? It is conceded that this property was stolen. The defendant admits that he had it in his possession. The detectives say they followed this man, no matter why they were there. That is their business. Detectives are employed by you to protect property and run down criminals, and their reasoning is not at all important in this case. They say they saw him go there twice that day. He admits that. He came out of the place and 2 packages of stolen goods came out. Whether he himself carried them is entirely immaterial. He admits that he got into a taxi with them and he was alone in that taxi cab with those goods. The law is that the recent unconscious and exclusive possession of stolen property raises a presumption of guilt. What does that mean? It means it is evidence of guilt unless the defendant satisfactorily explains his possession to the jury or gives such an explanation as to raise a reasonable doubt in your minds as to his apparent guilt. What have the people proven here? They have proven possession. There is no dispute as to that. Was it conscious, guilty possession or not? Did he know he had stolen property in that cab? That is for you to say. What does the evidence prove to you on that point? What does he do with it? Was he seeking to restore it to the true owner? That is the only reason why you may lawfully have stolen property in your possession. The police every day get stolen property to restore it to the true owner. That is why we hire them. That is not a crime, but anyone who aids or abets another, who helps another to withhold stolen property from the true owner, knowing what he is guilty of as to the crime this defendant is charged with, that of criminally receiving stolen property. Whether there was stolen property or not is ordinarily a question of fact.